Here's another question from Quora, and what I'm going to share is something that most people don't know, and they only realize that there may be a massive problem to their intellectual property strategy after they figure out how this actually works. So here's the question. I made a new invention and I have it patented in the US. Is it necessary to also patent it in China? My name is Andrei Mincov. I'm the founder of Trademark Factory, and I'm going to give you an answer to this question in a second. But just so you know, if you've got a question for me, whether it's about intellectual property, whether it's about branding, entrepreneurship, trademarks, make sure you post a comment below, and I do my best to answer your question. And also make sure you subscribe, because this is how you're going to find out when the next video goes live and if I answer your question. All right, so this is my answer to the question. Now, I don't know if it's necessary for you to patent your invention in China. If you make your product in China, or if you're afraid that somebody's going to make your product in China, you might want to get it patented in China. Your patent in the US allows you to stop others from selling your product in the US or making your product in the US. That's all it does. But here is the thing that the vast majority of people don't realize. Patents require worldwide novelty. And what that means is that you cannot patent something that is known to humanity anywhere in the world, including through your own patent filings, through your own patent applications in other countries. So when you file your patent in the US, guess what you did? You told the world about your invention. So anywhere in the world, it becomes prior art, which means that you cannot patent the same thing in those other countries. The only exception granted through international treaties, the Paris Convention, is a 6 months grace period during which your own patent application is not going to count against you. So if you filed your US patent less than 6 months ago, you can still possibly file for a patent in China, maybe in Europe, maybe in Mexico, maybe in wherever. But if it's beyond those 6 months, that's it. Even if you need a patent in China, you can't get it anymore. Out of luck. And like I said, most people, they have no idea about this. They would file their patent in the US and then wait until this product becomes big, and they're like, okay, great, let's patent it somewhere else. Can't do it anymore. Done. There is another possible exception with respect to, so Canada and US have got slightly different rules about your own patent application, so that period can be extended from 6 months to 12 months. And there could be special rules for provisional patents in the US, because really when you file a provisional patent, your invention does not get published. So the whole idea with the patents is that when you file for a real patent, you get monopoly over that invention in exchange for you disclosing the essence of your invention to the public. So you get a very brief period when you're the only one who can make the product or use the invention, and beyond that, everyone should be able to benefit from your invention, right? And the only way it works is that you have to disclose all that to the public, which is why it becomes prior art. With provisional patents, you don't really disclose the invention to the public. It sits with a it sits with a patent office, and until you convert it to the full patent. So if you've only filed for a provisional patent, you might be able to get away with it unless you've disclosed your invention to the world. Because what most people do when they file a US provisional patent, they feel it's safe for them to go out there and start pitching to the investors and start building the product and putting it out there. And once they do, they can still get the conversion from the provisional patent to the full patent, but they've pretty much killed their chances of getting that patent anywhere outside of the US. So, little disclaimer, we specialize in trademarks, we don't specialize in patents. We cannot help you file your patents, we're not going to do that. We can certainly recommend a firm that can help you with patents in the US and outside of the US, but that's not going to be us, and that's not something I'm going to be sharing in this video. But I understand patents enough to be able to answer this question. I hope it helps. If it does, make sure you comment below, make sure you like this video, and make sure you subscribe, like I said, to get notified whenever the next video goes live. And until then, I will see you in the next video, right?